Good morning, and thank you very much for joining me for our next Charity Bite-Size webinar, this time on investing charity money. So what are we talking about today? It's the new updated Charity Commission Guidance CC14. Now, what I'm not going to do is take you through line by line through the guidance, which I'm sure you'll be delighted to hear. I'm sure most of you have probably had a read through the new guidance already. It's been available since the beginning of August. So instead, what I'm going to focus on in the next 20-25 minutes, with leaving a bit of time for questions at the end, is what you see on the slide here. This is my agenda for this morning. Please do pop questions into the questions box as and when they occur to you. I will have a look at those towards the end of the session and answer as many as I can within the time available. If you're having any technical issues, any problems at all during the webinar, please put something in the chat and one of the technical team will assist you. So the agenda for this morning, I'm going to have a look primarily at what has changed. We've had CC14 guidance for a long time, but it's been completely overhauled by the Commission now. And the guidance is in a completely new format, very, very different look and feel. And it may be difficult for people at a glance, particularly if you don't have a copy of the old guidance to hand, to easily see what has changed and whether there's any new law that you need to be aware of. So that's what we're going to look at first. Then I'm going to focus in particular on two areas that many people are really interested in. The first being how the Commission has reflected the decision in the Butler-Sloss case within the new revised guidance. And then secondly, how it has integrated the guidance on social investment, which, as you'll recall, we had as interim guidance for a very long time. It's now integrated within the new guidance, and we're going to have a look at whether the new guidance provides any greater clarity or additional guidance on your powers to engage in social investment. I'm then going to give you a summary of some of the areas of omission within the new guidance, areas that are expressly not covered. And I mention these purely to just alert you to areas where you may previously have had a red flag or a little pointer or a bullet point within the old guidance to alert you to a potential issue with something that you're looking at, which is no longer there, and just to be aware and mindful of certain areas where further guidance might be needed. You might need to have a look at guidance elsewhere, or you might wish to seek some professional advice. And then finally, just because I think it's quite helpful to summarize this all together, I've put together a table which just summarizes where the Commission flags that you might want to seek further professional advice. It's not an obligation in a lot of cases. It is just a suggestion that in respect of certain decisions or areas of activity, you might wish to seek advice from a professional, whether that be a tax advisor, an accountant, an investment manager, a lawyer, or somebody else who's experienced in whatever it is that you are considering engaging in. So there's a table at the end, and I won't go through that in lots of detail, but when we get to that, you might want to take a screenshot of those slides or just revisit them, because this webinar will be available on our YouTube channel after today as usual. Okay, so starting at what has changed within the new guidance, what has the Commission done differently? Well, hopefully, if you've had a chance to look at it, you will have seen that the overarching difference is its look and feel. It's significantly simplified. The Commission has adopted a very plain English approach in the new guidance, trying to use simple language, far less terminology, and make it much more accessible to a much broader range of trustees. This is the direction of travel for all Commission guidance. We know that this is the way the Commission wants to take its guidance, to shorten it and make it more easily digestible for charity trustees. In a similar vein, there's no longer numbering. So all of the paragraphs, all of the sections you'll see when you look at it have no numbering. They used to have number 1 and 1.2, 1.3, all the way through the guidance. Now, as a lawyer, I like numbering, particularly when I'm trying to flag a particular section of the guidance to my clients. In advice, in an email, I can easily say, have a look at section 2.4 or whatever it might be of the Charity Commission's guidance. Well, that ease of cross-referencing is gone. And similarly, the Commission no longer makes the guidance available as a downloadable PDF. So I think that this, again, it's reflective of the Commission's approach of making its guidance all available on a website page, and it hyperlinks to different sections of the guidance rather than using paragraphing for cross-referencing. So it's just a different look and feel, essentially. Because of this simplification of the guidance, we've also seen a real change in terminology. And I think potentially quite unhelpfully, the Commission has omitted that section that you may be really familiar with that usually is included right at the beginning of guidance that explains what the Commission means by must and what the Commission means by should. Now, some of the guidance, the older guidance that's still available, has that in there. And if you look at that, it says, in this guidance, must mean something that is a legal or regulatory requirement or duty that trustees must comply with, and should mean something is good practice that the Commission expects trustees to follow and apply to their charity. So that sort of very simple clarification of what those two terms, which are used throughout the guidance, actually mean. That's no longer there, that clarification at the beginning of the CC14 guidance. So just bear in mind that you should assume that the Commission is still using those terms in the same way, even though it's not expressly saying that at the beginning of the guidance any longer. Similarly, you might remember that there used to be a really helpful annex, Annex 1, which listed all the technical terms used within CC14 guidance. That's gone. There's no glossary of terms, no explanation of what we mean by liquidity or investment manager or anything like that. Again, it's all because the Commission is trying to move to a simple English, simplified way of describing the guidance and avoiding too much jargon and terminology for charity trustees. And because of that, we've also seen a removal of the terms program-related investment, mixed motive investment, and ethical investment. Those labels for different approaches to investment have been removed, and instead the Commission just talks about different approaches in plain English. I mentioned that the guidance incorporates the old interim guidance on social investment, so it's intended to be comprehensive, everything under one document. And it includes some guidance on responsible investment, reflecting the decision in Butler-Sloss. Now, I've put question mark against the word comprehensive because, as I said earlier, I do think there are some areas that are missing from the guidance, and it's just worth being aware of what those key areas of omission are, and I'll come on to that shortly. Looking first at the Butler-Sloss decision, how is it that the Commission has reflected that decision in its new guidance? Well, before I touch on that, I'm going to just briefly recap the case. I'm sure most of you are very familiar with it by now, and we have got an article on or two articles on our website about the Butler-Sloss decision. If that's of interest to anybody, you can find those by just Googling Birketts Butler-Sloss. And you will find the articles, or having a look on the insights page of our website and browsing through historic articles. The case related to the Ashton Trust and the Mark Leonard Trust, both of which were grant-making charities that had adopted a specific focus on environmental protection as their charitable objectives. They were seeking declaratory relief from the court that the trustees had the power to adopt a particularly restrictive policy that negatively screened a large number of investment types from their policy in order to progress their objective of environmental protection. Now, the decision in the case, helpfully, in my view, clarified that ultimately decision-making about investments is down to the trustees, and it's not really any different to any other decision that you as a group of trustees may need to take. So just looking again at the key part of that judgment, which is paragraph 78, which is set out in full now in the legal underpinnings guidance that sits alongside guidance CC14. So if you do want to refresh yourself at any time of the exact wording in that judgment, you can find it in the legal underpinnings document, even though it's not set out expressly in this way in the CC14 primary guidance. But within that judgment, Mr. Justice Michael Green talked about the primary overarching duty of charity trustees to further the purposes of the trust. And because that is the starting point, it means that generally speaking, you would usually expect to achieve that by seeking to maximize returns, maximize your financial returns. So because you're trying to advance your charity's purposes, traditionally, you invest with a view to maximizing the income from those investments to give you more money to further your purposes and your activities in furtherance of those purposes. He clarified that if your governing documents expressly prohibit you from doing something, then of course you must follow your governing documents. And so all of this so far is pretty much the same as any decision. When you're looking to take a decision on anything for your charity, the starting point is your purposes. You're established to further specific charitable purposes. Everything you do must be done in the best interest of your charity in furtherance of those purposes, in accordance with your general duties as charity trustees. You then also have to act within your powers, within your governing documents. So you can't do something that is expressly prohibited by your governing documents. So far, so similar, very much the same as any decision. He goes on then to talk about the specific situations with investments where you might have a particular type of investment that potentially conflicts with your charitable purposes. And in the judgment, Mr. Justice Michael Green clarifies that there is no legal prohibition on charities investing in investment types that might potentially conflict with the charity's purposes, which is helpful. It means you don't have to find out whether or not something conflicts because you're prohibited by law from investing in it. So there's no absolute prohibition. But what he does say is that where there is a potential conflict with your charity's purposes, you do need to consider that. It's a relevant factor in deciding what you're going to do. It doesn't necessarily mean that you should negatively screen or exclude from your investments, although that is one decision you could reach. You might decide to retain some small shareholding in order to exercise rights of stewardship and influencing those companies as a shareholder, as an investor, having a voice within that sector, for example. So there are various decisions you could reach where you're faced with a potential conflict with your purposes. And what matters is that you are balancing all relevant factors. So what he says in the judgment is essentially trustees are required to act honestly, reasonably, with all due care and skill, and responsibly in formulating an appropriate investment policy for the charity that is in the best interest of the charity and its purposes. Where there are difficult decisions to be made involving potential conflicts or reputational damage, the trustees need to exercise good judgment by balancing all relevant factors, in particular, the extent of the potential conflict against the risk of financial detriment. And so again, it comes back to those normal principles of decision making. When you're taking a potentially controversial decision, a decision that might have financial repercussions or reputational impact for the charity, the more serious or the more significant that decision might be, the more robustly you need to consider all of the factors and have a really clear audit trail. So take advice if you think you need it. Have good quality board papers covering all of the relevant factors that you need to consider, and ensure that your minutes are detailed enough to demonstrate and illustrate a robust decision-making process. Now, what we do see with the Charity Commission these days is that they very rarely actually criticise a decision for the decision itself. Most of the time when trustees are criticised following a statutory inquiry or investigation, it's about process. It's about not having taken a decision in a way that demonstrates its reasonableness. But the court specifically emphasises this general position that, again, the Commission puts in its guidance on decision making. So this is in paragraph 78.10 of the judgment. The court says, if that balancing exercise is properly done and a reasonable and proportionate investment policy is thereby adopted, the trustees have complied with their legal duties in such respect and cannot be criticised, even if the court or other trustees might have come to a different conclusion. And the Commission adopts the same approach. So it doesn't matter if somebody else would have reached a different decision. What matters is that you can demonstrate the reasonableness of your decision. And so really what the court in summary was saying is, yes, all of these factors can be taken into account, and you have to adopt the same principles of good decision making as you would in respect of any other kind of decision. So how has the Commission addressed all of that within the guidance? Now, helpfully, at the very, very top of the guidance, if you look at the very beginning section headed Your Trustee Duties, The Commission mimics the language that we see in the judgment. So I explained that the opening part of that paragraph 78, Mr. Justice Michael Green says, charity trustees' primary and overarching duty is to further the purposes of the trust. The power to invest must therefore be exercised to further the charitable purposes. Well, if you compare that to the first paragraph of the guidance, it says, as trustees, your principal duty is to further your charity's purposes. This means that you must make your investment decisions to further those purposes. So again, the Commission is very much framing all of its guidance around that starting point in the judgment. It's mimicking that approach and language taken by the court. Helpfully, the Commission then doesn't categorise responsible investment as something that is different to financial investment. In the previous guidance, it was all dealt with sort of separately, and that's no longer the case. So if you're trying to find where the guidance on responsible investment is in the new guidance, and you're word searching the word responsible, you won't find it, because the Commission has intentionally moved away from having any sort of terminology to capture what we're talking about here. Instead, the Commission is saying, well, this is just a way in which you could approach your financial investments. This is an option for you. You can consider these things if it is appropriate and in the best interest of your charity. And so instead of finding a section that talks specifically about responsible investment, what the Commission has done is framed all of the guidance on financial investment decision making in the way that the judgment did. So what you'll see is that there's no headed section called responsible investment. Instead, if you scroll down to the section on financial investment, you will see that there is a heading called Example Approaches, Financial Investments. And within that, there are several bullet points telling you what sort of approach, what sort of investment approach you might decide to take as a group of trustees. And it lists various bullet points, including alongside a financial return, you might decide to avoid investments that conflict with your purposes or that might harm your charity's reputation. So it gives you a list of the sorts of things that you could take into account or the decisions that you could take. And helpfully, at the very bottom of those bullet points, it talks about choosing to engage in stewardship, so holding investments, perhaps in a class of investments that might potentially or do conflict with your charity's purposes, but in order to influence practice at those companies and make a difference through active investment. So it lists all of those as valid approaches that you could decide to take in the best interest of your charity, depending on your specific circumstances. So it's very flexible, very permissive in tone. In the next section, it then specifically draws out this issue around investments that conflict with your charity's purposes. Now, this is really important because, as I explained in the judgment, there is a specific section that talks about where there are difficult decisions to be made involving potential conflicts or reputational damage. You need to exercise good judgment by balancing all relevant factors, in particular the extent of that conflict against the risk of financial detriment. And I was a member of the Charity Law Association Working Party that did a review of the guidance before it went live. It was the user testing phase. And one of the things that we highlighted was that this particular point in the judgment really does need to be drawn out. So I'm delighted to see that the Commission included this section in the final guidance, because it makes it clear that where there is a potential conflict, where you think there's a risk of reputational damage, you cannot just ignore it. You do have to consider that. It is a relevant factor, and you have to balance that in making your decision. And if you don't, you may not be able to demonstrate that your decision is reasonable. So it is helpful that that is particularly drawn out. And again, that section cross-refers to the legal underpinning section, which sets out the language of that judgment in full. So social investment. Have we got any greater clarity in the way that social investment has been covered in the new guidance? Well, helpfully, it is expressly dealt with separately. Why is this important? Well, social investment engages in a completely different set of duties, and it's a completely different power. Not all charities have a power to engage in social investment. Most do, but Royal Charter charities and charities formed by statute are not included within the power under the Charities Act and would only have the power to engage in social investment if their governing documents expressly permit it. So that's quite important, and that is made clear in the beginning part of the guidance on what social investment means. It specifically says in that final paragraph that those particular types of charities may need to take advice if they're not sure about whether they have the power. Now, this is different to the standard financial investment power, where all charities will have the power to do that, unless their governing documents expressly prohibit it. So it is a different power. It is also subject to different trustee duties, and that's made clear in the new guidance. It talks about the fact that where you're engaging in social investment, the usual duties that apply to financial investment, so those are the ones set out in the Trustee Act, don't apply, and instead the specific duties set out in the Charities Act apply. And that's really important to be aware of, because you do need to be making those decisions under those other powers and looking at those different powers in the Charities Act. Now, where I think the guidance is limited and where I think it's a bit of a shame that it doesn't go into more detail is around some of the complexity that can arise with social investment. Tax issues and private benefit issues in particular are quite likely to arise when engaging in social investments, more likely than in sort of more classic and common types of financial investment, particularly where you're looking at investing in private companies or startup enterprises where there are tax risks to be aware of. A lot of this comes to what HMRC considers to be an approved charitable investment or loan, and this tends to apply quite commonly in social investment categories. Similarly, if you're investing in a private company that has only a small number of other investors, the private benefit issues there are much more acute than they would be in a PLC, for example, a listed company with loads and loads and loads of shareholders, because your investment as a charity in a company with just a handful of investors could create much more private benefit for those other investors than it would in a listed company. So there are those sorts of issues that are just not very well explained, in my view, in the guidance. And in particular, it just doesn't give very many illustrations or case studies about how to make decisions on social investments. And I think that we have actually lost some of the red flag areas that were included in the interim guidance. It was actually a lot more detailed in the interim guidance than it is in this final guidance. And that is a consequence of this approach of simplifying all of the guidance and trying to make it easily accessible. My main concern here is that social investments are not the sort of activity that the vast majority of charities will engage in. And if you're coming to the guidance looking for clarity about how to exercise your powers to engage in social investments, my worry is that most trustees will conclude that they need to take advice and that they can't proceed without getting express and specific advice on the particular proposal that they're looking at. So it is an area where I think, unfortunately, there isn't a lot more clarity. And I'm not convinced, I'd be interested to hear your views, but that trustees would come away from that feeling really confident that they are clear about what their powers are and how to exercise those powers in relation to social investment. Okay, so now looking at the areas of emissions, and this sort of segues nicely into this. You won't be surprised to hear that tax is an area that has been expressly excluded. I've mentioned it a couple of times. The Commission's guidance says expressly this guidance does not cover the tax implications of investments. So that's written in a very, very brief section on tax. And what it does instead is it cross-refers you to HMRC's guidance for charities about tax rules, which isn't as helpful as it could be because there's so much guidance on tax for charities. It will be very difficult for a lot of trustees to work out which bits are relevant and when they are an issue for specific types of investment. You don't know what you don't know, and the absence of red flags in the document, I think, is potentially problematic. The main areas that you need to be mindful of are areas listed in the investment types as high risk. So any high risk investments, there may be tax issues or trading issues to be mindful of, and social investment. So those are the areas that are more likely to have potential tax consequences where you might want to seek advice if you don't have tax experts within your trustee body or within your charity. So the really common sort of pooled investments in listed companies, getting a fund manager and putting all of your money into a portfolio, a really widely invested portfolio, you're not really likely to trip up over tax there, but it's the more high risk activities, the sort of social investment, the less common types of activities. So potentially the lack of red flag highlighting of tax issues in the new guidance might result in a disproportionate cost for charities that go beyond the most straightforward types of investment activities, but don't really have funds available for extensive professional advice. The other area that is not covered is investing in trading subsidiaries. It is mentioned, but it just simply cross-refers to the guidance on trading subsidiaries. So you would need to go there if you want to consider making investments in your trading subsidiary. And again, there are potential tax issues there if that's not done properly. And I mentioned already private benefit. There really is quite limited guidance on the private benefit issues. It cross-refers to the general private benefit and public benefit guidance of the Commission, but none of that guidance was written expressly with investments in mind. And so it's not particularly easy to navigate and work out what's relevant to you. I think one thing just to bear in mind that is not made terribly clear in the new guidance is there is a distinction between trustee benefits, where you need to have an express authorization for a benefit to a trustee or a connected person. So that may be where you're looking to invest in a company in which your trustee is also invested, for example, or where your trustee has a connection. And private benefits that are more than merely incidental. So that was my example of maybe a social investment with a small group of investors, the private benefit to those other investors potentially being more than merely incidental. Finally, where does the Commission suggest you might seek advice? As I said, I'm not going to go through these slides in any detail, so I'll just leave this one up for a second in case you want to take a screenshot or a screen grab or a photograph. You can revisit the guidance to have a look through this. And then there's a final slide. So just in a moment, I'm going to click and take you through to the final slide. So here's the final slide that has that continues that list. So these are the areas, and I've just summarized those because I think it's useful to know where the Commission has said you might need to seek further advice, because that would suggest that the guidance is not comprehensive in that respect. And if you're worried about anything in relation to any particular decision, that's where you might want to go and seek professional help. So that's everything that I'm covering today. I'm just going to have a look at the questions. I have a question here. Starting point is to maximize returns, which would usually mean higher risk. Surely the starting point is to preserve capital while seeking the best returns that this allows. In other words, appropriate risk-reward balance. It seems strange that the Butler-Sloss decision prioritizes return over capital preservation. So that's more of a comment, I think, than a question. Yes, I mean, I can read to you what it says in the judgment itself. It says it is normally achieved by maximizing the financial returns on the investments that are made. The standard investment criteria set out in Section 4 of the Trustee Act 2000 requires trustees to consider the suitability of the investment and the need for diversification, applying those criteria and taking appropriate advice so as to produce the best financial return at an appropriate level of risk for the benefit of the charity and its purposes. So I was sort of compacting that into the starting point is to maximize returns, but actually the judgment is clear that it is about balancing risk with return. And in the guidance itself, you will see that the Commission does have a section about risk and the kinds of risk considerations that you need to consider when you are making a decision about your investments. So it's not to say that the starting point being maximizing returns means you should ignore risk, you should ignore capital preservation. I think the other thing to mention there in response to that comment is whether or not you're seeking to maximize returns or preserve capital does also depend on whether you're dealing with the investment of permanent endowment or whether you're investing expendable endowment, what your time horizon is. for that investment. There are lots of different things that might apply. And there is a separate section on investing your charity's permanent endowment. It is quite brief, but there is a section in the guidance on that, which just highlights that different considerations may apply or do apply if you're dealing with the investment of permanent endowment. It's quite a large topic and not one we can cover in any more detail today, but that's a useful comment, so thank you very much. I'm now out of time for today, so thank you ever so much for attending. If you have any thoughts, comments, questions, anything that springs to mind as you consider what we've covered today, please do feel free to pop a comment to me on social media. I'm on LinkedIn. You can also contact me via the website or send me an email. I'll be happy to hear your feedback. And if you have time to complete the survey that will appear at the end of this webinar, I'll be most grateful for any feedback about how you found the session and any suggestions for future topics that you'd like us to cover. Thank you very much.